My chair was.
So here you go. So I just posted this on my Facebook page. It says, this is the last time I had to shovel a lot of snow. That's me. That's me.
Oh.
That's my brother. That's 1961,
I know the route
Meridian
well
Street
enough.
in Boston.
So I think we need to call, the call to order for the body. I'll swear everybody in, and then we can adjust the agenda after deliberations.
Okay. All right, well, then I'm going to call the body to order. Would you take the roll?
Mr. Desgeorge,
Here.
Mr. Wyatt,
Here.
Mr. Creech,
Here.
Mr. Cheffin,
Here.
Mr. Russo.
Here. Okay, so we're going to, next item on the business is the swearing in of BZA members. Counselor?
So I'd ask everybody to stand and raise their right hand. I state your name.
I, Philip Russo,
Solemnly swear
solemnly swear
that I will support the Constitution
I'll support the Constitution
of the United States
of the United
and the
States
state of Ohio,
and the state of Ohio,
and will obey the laws thereof,
and will
and
obey the laws thereof,
and that I will,
and that
and
I
I
will,
will
in all respects,
in all respects,
uphold and enforce
uphold and
the
enforce
provisions of the Charter
the
provisions of the Charter
and ordinances of the City of Oxford,
and
ordinances of the City of Oxford,
and will faithfully discharge
and will faithfully discharge
the duties of the Board of Zoning Appeals
the duties of the Board of Zoning Appeals
of the City of Oxford,
of the City of Oxford,
upon which I am a member.
upon which I am a member.
Thank you.
All right, so I think that's sworn in.
You want these signed?
Yes.
Let's go ahead and do that now.
You just pass them down if you like.
Well, we can gather them in deliberations and I can sign them to it.
Yeah, let's say I find myself without a pen.
We'll get it for you. We'll get them at the end. Okay, so we're in deliberation of a BZA 2025-03, 36 East High Street, the administrative appeal to section 1137.10C, replacement of a changeable marquee sign with electronic message boards. We completed the hearing in the November session. Mr. Grove, we have your objection to the 45-day, and upon the advice of counsel, we completed the hearing. So we met the requirement of the 45-day time span to complete the hearing in the November meeting. We have been since November in the deliberation phase of the case. But thank you for your.
Well, and I might add that the record here was substantial, and BZA needed an opportunity to review the record before it could complete its deliberations.
Yes, yes. And in that light, during deliberation, we received an additional summation from Attorney Grove that you all received, and I assume have read and internalized as additional information during our deliberations. And at this time, I want to ask the city, Zach, since you saw that as well, give you an opportunity if you want to add any additional information during our deliberation, just to make it fair in response to.
Objection, because he's a fact witness and you'd have to reopen your hearing phase in order to hear from him.
I think that the body can hear from him if they choose to. It's up to you.
You want to hear from Zach?
Yes. Seconded.
Okay. All right, we'll hear from Zach.
Okay.
Thank you. Noted. Your objection.
Yeah, so I just want to tell the board I'm happy to comment as much or as little as you wish me to in response to the testimony that you've heard and the exhibits that you've all received and had a chance to review. There are, however, a few remarks at minimum I wish to get on the record for everyone's benefit. I have reviewed in detail the appellant's summation as well as the expert report from the appellant's legal witness, Mr. Bridenstine. I did not review the architect's report in detail since I view that information as largely irrelevant to the BZA matter, and the architectural and aesthetic concerns have largely already been settled, seeing as how, and this was part of the previous testimony, that the Historic and Architectural Preservation Commission approved a certificate of appropriateness for this new set of marquee LED signs as of November 12th of last year. So reviewing all the facts, opinions, and information available, I have to honestly say that this case does leave me in a rather precarious position with respect to any final remarks that I might provide before board members re-enter your deliberation. I still believe, after reviewing all available evidence, that I, in my role as zoning administrator, appropriately and correctly interpreted and applied the relevant provisions appearing in the Oxford Planning and Zoning Code in correspondence to the exact language appearing in the code, as well as to all past precedent and interpretations from preceding city planners, which at least is known to me. However, as the appellant has pointed out, there are definitely some legal shortcomings in the present language that, if challenged in a court setting, I believe could prove difficult for the city to defend. While I do not believe deciding this appeal hinges on what could be characterized as a content-based restriction, I do recognize its existence in the code. I think I've been clear in my testimony that content-based restrictions have not and will not be enforced in light of constitutional case law. I understand that some or all of you, after reviewing the evidence that's been presented, may disagree with me and wish to reverse the original decision. I'm here to tell you that's okay. Per our zoning code, the Board of Zoning Appeals has the same powers as the office, my office as zoning administrator, upon which this particular administrative appeal has been filed. One thing I do want to make clear to all of you, the request that has been filed is an administrative appeal, not a variance. By filing an appeal, the appellant claims that staff has misinterpreted an existing section appearing within the zoning code. It is not a request for special relief from an existing provision of the code, which is linked only to a situation for a specific geographic location or on a particular piece of property, the way that a variance would be. If my original decision is reversed, you are essentially establishing new precedent with regard to how the present zoning language should be interpreted and applied in all future situations. The appellant states in their summation that a potential electronic signage moratorium and anticipated future code revisions are speculative and do not have relevance to this matter. I respectfully disagree. The appellant states that such information cannot contribute toward a denial of the requested sign, but I actually believe it's the contrary, that such information, knowing that a moratorium is on the way and that we anticipate future code revisions, actually lends support toward a reversal. This is because if the decision is reversed, you can rest assured that the sky will not fall, at least in zoning terms, because it is clear the city organization recognizes the shortcomings of the present regulation and is committed to a track that will ultimately see those shortcomings addressed. In other words, I don't think uptown Oxford is going to turn into a miniature Las Vegas overnight. Another thing I want to make clear to all of you, I do believe the arguments made with respect to private renewal and respecting the architectural integrity of this Art Moderne building do have merit. I think perhaps they have less merit in an appeal situation than they would during consideration of a variance, but that is somewhat beside the point. During my November verbal testimony, I noted a couple electronic changeable copy marquee signs that I was aware of, those being in downtown Miamisburg, Ohio, not too far away from here, as well as one that I happened to discover, kind of stumble upon while walking around downtown Providence, Rhode Island. And it is my sincere belief that those signs in those situations complement rather than detract from the architectural styling of each historic theater building. I suppose all of this is to say, if we had been confronted with a variance request rather than an appeal request, I imagine I would be leaning more toward a supportive stance. Lastly, as I've said, I've thoroughly reviewed both the summation and the legal report. I will comment that some arguments presented I agree with, and some I do not. I'm happy to go through the items one by one where there might be disagreement and offer you my reactions if the board wishes. But again, given my, as I characterized it, my precarious position and the stances I've just expressed to you, I'm not sure that that would be a worthwhile or productive use of our time. So with that, I'm happy to take any final questions, if we're able to entertain questions for the moment on this matter. Thank you in advance for your time, attention, and service related to this case, no matter the outcome.
I don't have any questions.
Zach, you testified earlier that you believe that your decision was sound based upon your interpretation of the code. You're not backtracking on that, are you?
I don't believe that I am, because I still feel that the decision that was rendered is consistent with past precedent and past interpretations. I do recognize that there is some legal risk inherent to the stipulation that changeable copy signs apply to fuel pricing. That is a content-based restriction and cannot be enforced. What is legal is restricting sign types based on land use. So if you were to not consider the last part of the relevant sentence of the code that talks about changeable copy signs being permitted for fuel dispensing stations to display the price of fuel, the only problematic part of that statement is the last part about fuel pricing. So as long as you are not regulating based on content, as long as you don't have to look at the message of the sign to know how to regulate it, it is legal and lawful. And it is legal and lawful to regulate sign types based on land use. In this situation, as the code is written, it talks about a fuel dispensing station. That is a form of land use. That has no bearing on content. So I think that part is defensible, but given that there's some content-based, well, content kind of mixed together in the same sentence of the code, I think there is some inherent legal risk as the code is presently written.
But wasn't your testimony, your recommendation based upon the fact that this is a non-conforming use and there's a substantial change being required? It's like a replacement as opposed to a maintenance issue. Wasn't that your point?
So the first part of what you said, and this is kind of perhaps getting into what some of my criticisms would be of the arguments made in the summation and in the legal experts report. I don't believe a sign is a use. A sign is an accessory to property. It's an accessory improvement. So I don't think that when when the Ohio Revised Code mentions non-conforming use, it's not referring to signage. It's referring to principal land uses of property. In this situation with 36 East High Street, Brick Street, it is the land use that is the subject of this case is a music venue. It is not, we're not talking about signage as a use. To me, signs are not uses. So that was the first part that kind of resonated with me with your question. What was the second part of your question, if you don't mind repeating?
Okay, I'm trying to remember exactly how you worded it.
You
but
asked about replacement.
Yes, you found that it wasn't a like-for-like replacement, it was a substantial change, or at least a change.
In my view, it's a sign replacement, and the code explicitly says when you are replacing a non-conforming sign, that it must meet the current regulations of the code. That much is clear in the code.
Can I ask you, do you feel that this is a change, the use, or the replacement, the fact that it's being replaced? is
I believe it's a
change?
replacement.
Okay, you won't want to use the word change then? You're not comfortable with that word?
I typically use the word change with respect to use, which, as I just stated,
I
to
think
me, it's not a use.
I'm not understanding you completely. I think you're changing a little bit your approach to the analysis. Am I wrong about that?
I think he's providing us with a much more nuanced, I think, interpretation of replacement and use.
Yeah, again, to me, a sign is not a use. To me, what we've got going on here is an existing non-conforming sign that is being replaced, and the code very clearly states that when such signs are replaced, they lose their non-conforming designation, which still means that you can put up a new sign, it just has to conform to the current regulations.
Because it's clear that no land use shall be changed without certification by the zoning, 112901, that's clear, right? They can't replace, they can't
But sign is
change.
not a use,
To me, a sign is not a use.
right? Yes.
Find myself about. Okay, I'll scan all these and put them into our records.
Okay, we have returned and completed our deliberations. We are in public session at this point. Is there a motion?
I'd like to make a motion, Mr. Chairman. I would like to move that the board direct the law director to draft a written decision denying the appeal, and that this decision will be reviewed by us and voted on at the next meeting.
Well, the decision will be adopted at the next, the written decision will be
Adopted at the
adopted.
next
That would
decision.
trigger the appeal, right?
And make sure we have a chance to review that decision and conforms with our findings.
Okay, everyone understand the motion? Is there a second?
Second.
It's been moved and seconded. All in favor indicate by saying aye.
Aye.
Opposed? Hearing none, the motion has passed. One final comment to the applicant. We encourage the applicant to submit a variance for this request, and we probably could even expedite and find a meeting date that,
Well, I would think if the variance requests were submitted, it could be made for the part of the February agenda, wouldn't it? Any reason it couldn't?
I would believe so.
Yeah, typically we would be notifying everyone, surrounding properties. Yeah, I'd have to take a look at our timelines, but I mean,
I mean, the
we
fact
could
is-
make an exception in this case too, since there's already been,
Well, the record is, it exists. I don't think there's a reason to have to do anything other than the record.
No later, that it would be taken up no later than the February meeting. Let's put it that way.
okay, which would be February 24th would be the next
No
regular
later
meeting.
than the February meeting.
Jack, is that possible for you to get an application by then?
I don't know. I mean, I have to take it up with my client.
Okay.
And I've got other limitations, so.
Okay.
I don't know how soon it has to be before the February 24th meeting for purposes of processing and staff, reporting and all of that. So what's the deadline, Zach?
I can look it up real quick.
Well, I don't think we need that.
Well,
That's
that conversation can
That,
happen.
that can happen
You could
between
move on to the,
you and the applicant afterwards. Our final order of business is we've all been sworn in for the 2026 year. Final order of business is the election of officers for the Board of Zoning Appeals. Are there any nominations?
Mr. Chairman, I would like to nominate Mr. Russo as chair.
Is there a second?
Second.
Any other nominations? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Abstentions? Great. Any other nominations for vice chair?
I don't think I should nominate myself.
Oh, yes. I would like to nominate for vice chair Steve Chafin.
I'll accept.
Second?
There's a nomination for Steve Chafin to fill the role of vice chair.
Second.
Any other nominations? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed?
Abstain.
Abstentions?
Abstain.
All right, what, you have to approve the minutes from last meeting.
We got secretary to elect first.
Oh,
I move
Yeah.
that Mr. Creech be appointed secretary.
Is there a second?
Second.
Any other nominations? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Abstentions?
Abstain.
Congratulations, Mr. Creech. You are
Thank you.
secretary of the BZA. Final order of business is to approve the minutes from the last meeting. You've all seen them. Any modifications, changes?
I move to approve.
There's a motion to approve. Second?
Second?
All in favor indicate by saying aye.
Aye.
They are approved. Is there a motion to adjourn?
I move to adjourn.
It's been moved. Seconded?
Second?
It's been seconded. All in favor indicate by saying aye.
Aye.
Opposed? We are adjourned. Thank you very much.
Well, we'll see if that works out. Okay.
Who knows?
Still missing two of these.
Did you give?
Make sure you turn in your.
I gave mine to Matt.
Oh, yeah.
Right here. You'll have mine.
Okay. Miami versus UMass.